The conference room at the National Press Club in Washington fell into complete silence as Representative Jasmine Crockett held up a single document, her expression calm, but her eyes conveying unmistakable certainty. Across the table sat Alan Dershowitz, the Harvard law professor emeritus, whose decades of prominence in constitutional law had given him a platform to defend positions that increasingly diverged from mainstream legal scholarship, particularly his arguments that prosecuting former presidents would violate constitutional principles and establish dangerous precedents that would undermine American democracy. For months, Dershowitz had been making these immunity arguments across television networks and in legal journals, presenting them with the confidence of someone whose credentials commanded deference and whose interpretations shaped public understanding of complex constitutional questions. But what happened in the next 30 seconds did not just leave Dershowitz speechless, it exposed fundamental flaws in his immunity theory that would trigger reactions from attorneys across the nation who had been waiting for someone to systematically challenge arguments that sounded authoritative but that rested on questionable legal foundations. If you want to see exactly how a member of Congress with a public defender background dismantled decades of constitutional argumentation from one of America's most famous law professors, and why thousands of attorneys celebrated what they witnessed, make sure you subscribe to this channel and hit that notification bell, because this story reveals why credentials alone cannot protect flawed legal reasoning from rigorous challenge. The press conference had been organized by the American Constitution Society to discuss presidential accountability and the role of criminal prosecution in maintaining checks on executive power, topics that had become increasingly urgent as Donald Trump faced multiple indictments in federal and state courts for conduct ranging from retaining classified documents after leaving office to attempting to overturn election results through pressure on state officials and through incitement of violence on January 6th. The panel featured several constitutional law professors from major universities, 2 former federal prosecutors with experience handling white-collar crime and public corruption cases, a retired federal judge who had presided over significant constitutional litigation during her career, and the 2 politicians with legal backgrounds who could speak to practical questions about how constitutional principles operated in actual governance contexts. Alan Dershowitz had spent his career building reputation through his Harvard affiliation, through his representation of controversial clients in high-profile cases including O.J. Simpson and Jeffrey Epstein, and through his prolific writing and media appearances where he presented himself as a principled civil libertarian who defended constitutional protections regardless of whether doing so served his personal political preferences or whether it required defending unpopular clients whose rights were being violated by government overreach or public hysteria. His immunity theory had become central to his recent work defending Trump against criminal prosecution, and he had articulated this theory in numerous media appearances and in written commentary with arguments that combined legitimate constitutional concerns with claims that many legal scholars found questionable or that appeared designed more to protect Trump than to articulate neutral principles about executive accountability. The core of his immunity argument was that prosecuting former presidents would establish unprecedented and dangerous precedent that would inevitably lead to cycles of political retaliation where each party, upon gaining power, would prosecute officials from the previous administration, transforming American democracy into something resembling countries where political opponents routinely faced imprisonment after losing elections, and where the prospect of prosecution would distort presidential decision-making by causing presidents to prioritize self-protection over effective governance. Dershowitz presented this argument as reflecting principled concern about constitutional structure and about preserving democratic norms rather than as defense of Trump specifically, and he framed his position as consistent with founding principles and with the framers' understanding that the presidency required certain protections to function effectively as coordinate branch of government rather than as subordinate to legislative or judicial oversight that might be deployed for partisan purposes. Representative Jasmine Crockett had been invited to the panel because of her legal background as public defender and because of her increasingly prominent role in congressional debates about accountability and justice, bringing practical experience from representing clients in criminal justice system to discussions that often remained abstract when conducted solely among academics who had spent careers theorizing about law without experiencing how it operated for ordinary people facing prosecution. She had graduated from Texas Southern University's Thurgood Marshall School of Law, a historically black institution that serves students who might not have access to elite legal education, but that produce graduates whose practical skills and commitment to justice often exceeded what elite institutions provided, despite their superior resources and prestige. Her 6 years as public defender in Dallas County had given her direct experience with constitutional law as it operated in trial courts where Fourth Amendment protections against unreasonable searches, Fifth Amendment rights against self-incrimination, Sixth Amendment guarantees of effective assistance of counsel, and Eighth Amendment prohibitions on cruel and unusual punishment were litigated in contexts where mistakes meant clients lost their freedom rather than simply receiving lower grades or critical reviews. She had prepared extensively for the press conference by studying Dershowitz's immunity arguments as he had articulated them in various forums, by researching constitutional text and founding documents that bore on questions of presidential accountability, by reviewing Supreme Court precedent addressing executive power and criminal liability, and by consulting with constitutional scholars and former prosecutors who could help her identify weaknesses in Dershowitz's reasoning that might not be immediately apparent, but that would become clear under sustained examination. Her preparation reflected understanding that challenging prominent legal scholar required not just disagreeing with his conclusions, but demonstrating through rigorous analysis that his arguments rested on flawed premises or on selective interpretation of constitutional sources that ignored contrary evidence or that failed to apply stated principles consistently across cases. She recognized that Dershowitz's confidence in his immunity theory derived partly from his credentials and his decades of prominence in constitutional debates, advantages that might intimidate less prepared opponents into accepting his framing or into offering only weak objections that he could easily dismiss by citing his experience or by suggesting that critics simply did not understand the sophisticated constitutional analysis underlying his positions. The press conference proceeded through its initial stages with various panelists presenting their perspectives on presidential accountability and on the constitutional questions raised by Trump's prosecutions, with generally respectful disagreement about how to balance concerns about politically motivated prosecution against the need to ensure that presidents faced accountability for serious criminal conduct rather than being effectively above the law because of their political status. When Dershowitz was recognized to present his immunity theory, he delivered a polished presentation that emphasized the unprecedented nature of prosecuting a former president, the dangers of establishing precedent that would politicize criminal justice system by making prosecution decisions depend on partisan calculations rather than on neutral application of law, and the risk that cycles of retaliatory prosecution would undermine democratic governance by creating incentives for presidents to refuse to leave office peacefully if losing power meant facing criminal charges. His presentation employed his characteristic rhetorical techniques of citing founding principles and constitutional structure, while avoiding engagement with specific textual provisions or historical examples that might complicate his narrative, and of framing his position as defending timeless constitutional values against contemporary political pressures that threatened to subordinate law to partisan warfare. He argued that the framers had designed the presidency to be a strong and independent executive who could act decisively without constant fear of legal harassment from political opponents, and that allowing criminal prosecution of former presidents would undermine this constitutional design by making presidents vulnerable to charges that might be technically supportable under criminal statutes. But that reflected policy disagreements or partisan animosity rather than genuine criminal conduct deserving punishment. He suggested that impeachment was the appropriate mechanism for presidential accountability during a president's term, and that the political remedy of electoral defeat was the appropriate response to presidential misconduct that did not rise to the level of impeachment, but that criminal prosecution after leaving office threatened to transform disputes that should be resolved through political processes into criminal matters that would poison democratic competition and that would establish precedent allowing each party to use criminal law as weapon against opponents. His argument sounded sophisticated and principled when presented with his professorial authority and when framed as protecting constitutional structure rather than protecting Trump specifically. And several journalists and some panelists appeared persuaded or at least uncertain about how to respond to claims that invoked founding principles and that warned of dire consequences from prosecuting former presidents. When the moderator invited other panelists to respond to Dershowitz's immunity theory, Jasmine Crockett indicated that she wanted to address his arguments directly because she believed they contained fundamental flaws that needed to be exposed through careful analysis of constitutional text, founding history, and Supreme Court precedent that Dershowitz had either ignored or had misrepresented in ways that might not be apparent to audiences lacking detailed knowledge of these sources. She began by acknowledging that concerns about politically motivated prosecution were legitimate and deserved serious consideration, but she noted that such concerns needed to be balanced against the equally serious danger of allowing presidents to commit crimes without facing accountability. And she suggested that Dershowitz's immunity theory failed to engage honestly with this balancing, because his arguments were structured to reach predetermined conclusion that Trump should not be prosecuted regardless of evidence against him. She explained that she wanted to examine his immunity theory systematically by testing whether it rested on accurate characterization of constitutional text and founding understanding, whether it reflected actual Supreme Court precedent on presidential accountability, whether it was applied consistently across cases involving different presidents and different types of alleged criminal conduct, and whether its logical implications were ones that Dershowitz himself would accept when those implications were made explicit. She pulled out the document she had been holding since the press conference began, and she explained that it was a copy of Article 2 of the Constitution, which established the executive branch and which defined presidential powers and limitations. And she noted that she wanted to start by examining what the constitutional text actually said about presidential immunity from criminal prosecution, because Dershowitz's theory claimed to rest on constitutional structure, even though the Constitution did not explicitly grant presidents immunity from prosecution, and even though founding documents suggested the framers intended presidents to be subject to criminal law. She read from Article 2, Section 4, which provided that the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors, and she noted that this provision established impeachment as mechanism for removing presidents from office, but did not suggest that impeachment was the only accountability mechanism, or that criminal prosecution was precluded. She explained that the constitutional text distinguished between impeachment, which resulted in removal from office, and criminal prosecution, which could follow impeachment or which could occur after a president left office through electoral defeat or term limits. And she noted that this distinction suggested the framers contemplated that presidents would face criminal accountability through normal legal processes rather than being immune from prosecution because of their office. She then addressed Dershowitz's claim that prosecuting former presidents would establish unprecedented and dangerous precedent by noting that the precedent question depended on what one meant by precedent and on whether one focused on actual prosecution or on the legal principle that presidents could be prosecuted. She explained that while no former president had actually been prosecuted before Trump, the legal principle that presidents were not immune from criminal prosecution had been established through multiple sources, including founding documents, early presidential practice, Justice Department legal opinions, and Supreme Court precedent that consistently recognized that presidents were subject to law and that their office did not provide immunity from criminal accountability. She cited Federalist 69, where Alexander Hamilton had explicitly contrasted the president's vulnerability to prosecution with the British monarch's immunity, noting that Hamilton wrote that the president would be liable to prosecution and punishment in the ordinary course of law after leaving office, language that clearly established founding, understanding that presidents did not possess immunity that would prevent their prosecution for criminal conduct. She explained that Dershowitz's immunity theory required ignoring or dismissing this founding evidence because it contradicted his claim that prosecuting presidents violated constitutional structure, and she suggested that his selective engagement with founding documents revealed that his theory was designed to reach desired conclusion rather than following where constitutional text and founding history actually led. She pulled out additional documents showing Supreme Court precedent addressing presidential accountability, and she noted that the court had consistently rejected claims of absolute presidential immunity in contexts ranging from civil litigation to criminal investigation, establishing, through decisions like United States versus Nixon, that presidents were not above the law and that their office did not provide immunity that would prevent legal process from reaching them when they engaged in wrongful conduct. She explained that Nixon held that presidents had to comply with subpoenas for evidence needed in criminal trials, even when compliance might be politically damaging, and that the court's reasoning rested on the fundamental principle that no person, not even the president, was above the law or immune from legal accountability. She noted that Dershowitz's immunity theory was inconsistent with this Supreme Court precedent because it claimed that constitutional structure required treating presidents as immune from prosecution, even though the court had repeatedly rejected immunity claims and had established that presidents were subject to legal process and legal accountability. She challenged Dershowitz directly by asking whether his immunity theory meant that he believed Supreme Court precedent was wrong and that the court should overturn decisions like Nixon that rejected presidential immunity claims, or whether he was arguing that immunity from prosecution was somehow different from immunity from other legal processes in ways that he needed to explain because the constitutional principles appeared identical across contexts. She noted that if constitutional structure required treating presidents as immune from prosecution to protect their ability to govern effectively, then the same logic would seem to require immunity from civil litigation, from criminal investigation, from congressional oversight, and from other legal processes that might distract presidents or that might be used for partisan purposes. Yet the Supreme Court had consistently rejected such broad immunity claims in ways that suggested the court did not accept the constitutional logic underlying Dershowitz's theory. She then turned to what she described as the most fundamental flaw in Dershowitz's immunity theory, which was his claim that prosecuting presidents would establish dangerous precedent leading to cycles of political retaliation, because this claim rested on assumption that the real danger was prosecution rather than the crimes that prosecution would address. She explained that focusing on prosecution as the danger inverted the proper analysis because it treated holding powerful people accountable as more threatening to democratic governance than allowing powerful people to commit crimes without facing consequences. And she noted that this inversion revealed the anti-democratic implications of immunity theories that prioritize protecting presidential power over ensuring presidential accountability. She argued that the actual dangerous precedent would be established by not prosecuting Trump, despite substantial evidence that he had retained classified documents in violation of federal law. that he had obstructed justice by refusing to return documents and by directing subordinates to hide documents from investigators, that he had conspired to overturn election results through fraudulent elector schemes and through pressure on state officials to falsify vote counts, and that he had incited violence to prevent peaceful transfer of power, because failing to prosecute such serious criminal conduct would establish that presidents were effectively above the law as long as they maintained political support or as long as prosecutors feared that accountability would be characterized as political persecution. She noted that Dershowitz's concern about cycles of retaliation prosecution assumed that future prosecutions would be unjustified and politically motivated rather than based on actual evidence of crimes, but she pointed out that this assumption was itself politically motivated because it presumed that Trump's prosecutions were unjustified despite extensive evidence developed through grand jury processes and despite charging decisions made by prosecutors who would face professional and legal consequences if they brought charges that were not supported by evidence. She explained that the proper way to prevent politically motivated prosecution was not to create immunity that would allow presidents to commit crimes without accountability, but rather to maintain institutional safeguards, including grand jury review of charging decisions, judicial oversight of prosecutions through preliminary hearings and trials, and appellate review of convictions, all mechanisms that already existed in criminal justice system, and that would prevent unjustified prosecutions from succeeding, even if they were initially brought. She argued that Dershowitz's immunity theory essentially proposed abandoning these institutional safeguards in favor of blanket immunity that would protect guilty presidents as well as innocent ones, an approach that prioritized protecting presidential power over ensuring accountability in ways that contradicted fundamental principles that no person was above the law. She then delivered the observation that would become the most quoted portion of her response, and that would trigger widespread reaction from attorneys nationwide who had been frustrated by Dershowitz's immunity arguments, but who had struggled to articulate comprehensive challenge to his reasoning. She noted that Dershowitz's entire immunity theory rested on assumption that the greater constitutional danger came from holding presidents accountable rather than from allowing presidents to commit crimes, and she stated that this assumption revealed profound misunderstanding of what constitutional democracy required, because constitutional systems depended on accountability mechanisms that ensured powerful officials faced consequences for wrongdoing rather than on immunity that allowed powerful officials to act without constraint. She explained that the framers had fought a revolution against monarchical immunity and had designed the Constitution specifically to ensure that American presidents would not possess the immunity that British monarchs enjoyed, and she noted that returning to immunity, principles that the founding generation had rejected, would represent betrayal of constitutional design rather than fulfillment of it. She concluded by stating that Dershowitz's immunity theory ultimately failed because it could not be reconciled with constitutional text that didn't grant presidents immunity from prosecution, with founding documents that explicitly contemplated presidential prosecution, with Supreme Court precedent that rejected presidential immunity claims, or with constitutional principles that no person, including presidents, should be above the law. She noted that the only way to accept his immunity theory was to ignore these constitutional sources, or to engage in reasoning that prioritized protecting Trump over maintaining constitutional accountability, and she stated that attorneys nationwide who understood constitutional law and who valued rule of law principles would recognize that his immunity arguments represented special pleading rather than serious constitutional analysis. The room fell into profound silence as she concluded her systematic dismantling of Dershowitz's immunity theory, with Alan Dershowitz sitting visibly stunned by the comprehensiveness of her critique and by her demonstration that his supposedly sophisticated constitutional arguments rested on foundations that could not withstand rigorous examination. The immediate aftermath of the press conference saw explosive reaction across legal communities as attorneys, constitutional scholars, former prosecutors, judges, and law professors responded to video clips of Crockett's systematic demolition of Dershowitz's immunity theory that spread rapidly through social media and legal news outlets. Within hours of the press conference concluding, multiple prominent constitutional law professors had published detailed analysis praising Crockett's legal reasoning and explaining why her critique had identified genuine flaws in Dershowitz's arguments that many legal scholars had recognized, but that had not been articulated so comprehensively in public forum that would reach audiences beyond academic circles. Professor Lawrence Tribe of Harvard Law School, himself one of the nation's most distinguished constitutional scholars, wrote extensive social media thread explaining that Crockett had provided exactly the kind of rigorous constitutional analysis that debates about presidential accountability required, noting that she had demonstrated mastery of constitutional text, founding documents, Supreme Court precedent, and constitutional principles that allowed her to expose weaknesses in Dershowitz's immunity theory that might not be apparent to general audiences, but that were immediately recognizable to constitutional lawyers as fundamental logical and legal flaws. Professor Tribe explained that Crockett's critique was particularly effective because she hadn't simply disagreed with Dershowitz's conclusions or offered alternative policy arguments, but rather had demonstrated through careful textual and precedential analysis that his immunity theory contradicted constitutional sources that he claimed supported his position. Professor Tribe noted that Crockett's point about Federalist 69 was devastating to Dershowitz's argument because Hamilton's explicit statement that presidents would be liable to prosecution in the ordinary course of law directly contradicted claims that constitutional structure required treating presidents as immune from prosecution, and that Dershowitz's failure to address this founding evidence revealed that his theory was not actually grounded in constitutional text or founding understanding, despite his framing. Professor Tribe also praised Crockett's analysis of Supreme Court precedent, noting that her observation that the court had consistently rejected presidential immunity claims undermined Dershowitz's attempt to rely on constitutional structure arguments when that structure had been interpreted by the court in ways that contradicted his immunity theory. He concluded his analysis by suggesting that Crockett's performance at the press conference had established her as a serious constitutional thinker, whose legal analysis deserved attention from scholars and practitioners who might otherwise dismiss politicians as lacking the expertise or the analytical rigor necessary for sophisticated constitutional discourse. Dean Erwin Chemerinsky of Berkeley Law School published an article in Legal Journal analysing the press conference and explaining why Crockett's critique of Dershowitz's immunity theory was significant for both legal doctrine and for public understanding of presidential accountability. Dean Chemerinsky noted that presidential immunity arguments had gained traction, partly because they sounded reasonable when presented by credentialed scholars like Dershowitz, whose reputations led audiences to assume their constitutional interpretations reflected serious analysis rather than partisan advocacy. And he explained that Crockett had performed valuable service by demonstrating, through rigorous engagement with constitutional sources, that immunity arguments did not withstand scrutiny when examined carefully against text, history, and precedent. He praised her specifically for identifying the logical flaw in Dershowitz's claim that prosecuting presidents established dangerous precedent while ignoring that not prosecuting presidents, despite evidence of serious crimes, established its own dangerous precedent that powerful officials were above the law. And he noted that this point revealed the anti-democratic implications of immunity theories that prioritize protecting presidential power over ensuring accountability to law. Former federal prosecutors joined constitutional scholars in praising Crockett's analysis, with particular focus on her observation that institutional safeguards already existed in criminal justice system to prevent politically motivated prosecutions from succeeding. Preet Bharara, who had served as United States Attorney for the Southern District of New York before being fired by Trump, published commentary explaining that prosecutors understood what Dershowitz apparently did not, which was that bringing unjustified charges against prominent defendants carried substantial professional and legal risks that deterred politically motivated prosecutions even without blanket immunity. Barrara explained that prosecutors who brought charges not supported by evidence would face sanctions from judges, would risk losing cases at trial with resulting damage to their reputations, and would potentially face disciplinary action or even criminal prosecution themselves if their conduct violated laws governing prosecutorial behaviour. He noted that these institutional safeguards provided far better protection against politically motivated prosecution than blanket immunity would provide, because safeguards allowed legitimate prosecutions to proceed while preventing unjustified ones from succeeding, whereas immunity would protect guilty as well as innocent presidents and would establish that powerful officials could commit crimes without facing accountability as long as they maintained political support. Retired federal judges added their voices to growing chorus of legal professionals praising Crockett's constitutional analysis, noting that her arguments reflected understanding of how constitutional principles operated in actual legal practice rather than in abstract theory. Judge Nancy Gertner, who had served on the Federal District Court in Massachusetts before retiring to teach at Harvard Law School, wrote that Crockett's press conference performance demonstrated why practical legal experience mattered for constitutional analysis, explaining that Crockett's background as public defender had given her direct engagement with how constitutional protections worked in criminal cases and with how legal system balanced individual rights against state power. Judge Gertner contrasted this practical experience with Dershowitz's primarily academic and appellate practice that kept him removed from trial courts where constitutional questions were litigated in contexts requiring immediate application rather than abstract theorizing, and she suggested that Crockett's superior grasp of constitutional principles reflected her experience applying those principles in cases where mistakes had serious consequences rather than simply discussing them in academic settings, where errors might be overlooked or dismissed as reasonable disagreements. State and local bar associations began organising events featuring discussions of the press conference and of the constitutional questions it raised, with many inviting Crockett to speak about presidential accountability and about how attorneys should approach constitutional interpretation when political pressures might tempt abandonment of rigorous analysis in favour of reaching conclusions that served partisan preferences. The American Bar Association issued a statement noting that the exchange between Crockett and Dershowitz exemplified the kind of serious constitutional discourse that the legal profession should prioritise, praising both participants for engaging with complex questions through reference to constitutional sources rather than through simple assertion of competing conclusions, though the statement's even-handedness was undermined by the reality that Crockett's analysis had been far more rigorous and far more grounded in constitutional text and precedent than Dershowitz's immunity theory had been. Legal publications including the National Law Journal, the American Lawyer, and specialized constitutional law journals published extensive coverage of the press conference and of the legal community's reaction, with articles examining specific aspects of Crockett's constitutional analysis and explaining why her arguments had resonated so strongly with attorneys across ideological spectrum. These publications noted that Crockett had succeeded in doing what many legal scholars had attempted but had not accomplished as effectively, which was demonstrating through accessible explanation grounded in constitutional sources that presidential immunity arguments were not supported by text, history, or precedent despite being presented with confidence by credentialed advocates. The articles explained that her success reflected combination of thorough preparation, clear communication that made complex constitutional arguments accessible to general audiences, and willingness to directly challenge prominent scholar rather than deferring to credentials or reputation. Social media platforms saw unprecedented engagement from attorneys who shared clips of the press conference and who expressed appreciation that someone had finally provided comprehensive refutation of immunity arguments that had frustrated legal professionals who recognized their flaws, but who lacked platforms to reach audiences beyond their immediate professional circles. The hashtag Crockett Constitutional Analysis began trending among legal professionals, and thousands of attorneys changed their social media profiles to include references to her press conference performance as example of the kind of rigorous legal reasoning that the profession should aspire to maintain. Several prominent attorneys noted that they were assigning video of the press conference to law students and to junior associates as example of effective legal argumentation and as demonstration that thorough engagement with constitutional sources mattered more than credentials or confident presentation when evaluating quality of constitutional analysis. For Alan Dershowitz personally, the press conference represented another devastating blow to credibility that had already suffered significant damage through his Trump-era constitutional arguments and through previous confrontations where his work had been shown to contain errors or to rest on selective use of sources. His immunity theory had been central to his recent media appearances and to his positioning as constitutional scholar defending important principles rather than simply defending Trump, and having that theory systematically dismantled through demonstration that it contradicted constitutional texts, founding documents, and Supreme Court precedent created lasting damage that would make it difficult for him to continue presenting immunity arguments with confidence or to maintain his claims to authoritative constitutional expertise. Several media outlets that had regularly featured him began reconsidering whether his appearances provided value, or whether his demonstrated tendency to produce constitutional arguments that did not withstand scrutiny made him unreliable as legal analyst. For Jasmine Crockett, the press conference elevated her status within legal communities and established her as a serious constitutional thinker whose analysis commanded respect from scholars and practitioners regardless of their political orientations or their views about her policy positions. The recognition that her constitutional reasoning had impressed lawyers across ideological spectrum demonstrated that quality of legal analysis could transcend partisan divisions when advocates prioritize rigorous engagement with constitutional sources over reaching conclusions that serve political preferences, and it provided powerful evidence that her legal education at Texas Southern had prepared her excellently for sophisticated constitutional analysis, despite prestige hierarchies that often led elite lawyers to dismiss graduates of non-elite institutions. She received numerous invitations to speak at law schools, at bar association events, and at constitutional law conferences, recognition that reflected her elevated status as someone whose constitutional analysis deserves serious attention from legal academics and practitioners. What happened at that press conference was not just another political debate or another confrontation between opposing viewpoints about presidential accountability. It was a demonstration of why constitutional analysis requires rigorous engagement with text, history, and precedent rather than simply confident assertion of conclusions that sound reasonable when presented by credentialed scholars, but that collapse under scrutiny from opponents who have actually studied constitutional sources carefully and who can identify where supposedly sophisticated arguments depart from what the Constitution actually says and what founding generation actually believed. Jasmine Crockett showed attorneys nationwide that presidential immunity theory promoted by Alan Dershowitz was not serious constitutional analysis, but was rather special pleading, designed to protect one president from accountability for serious alleged criminal conduct. And she did this by simply reading what the Constitution said, by citing what founding documents established, and by explaining what Supreme Court precedent held, demonstrating that sometimes the most effective constitutional arguments are those that take founding texts and judicial decisions seriously rather than treating them as malleable materials to be shaped into whatever forms serve contemporary political preferences. If this analysis of how a systematic constitutional argument can expose flawed immunity theories and why thousands of attorneys celebrated seeing rigorous legal reasoning triumph over credentialed assertions, helped you understand why constitutional law matters, and why the legal profession values practitioners who prioritize textual fidelity and precedential consistency over partisan outcomes, then make sure you subscribe to this channel and turn on notifications, because we will continue covering the moments when careful legal analysis cuts through political rhetoric, and when commitment to constitutional principles demonstrates why rule of law requires that even presidents must face accountability when they violate the criminal statutes that apply to all Americans, regardless of their political power or their claims that prosecution would establish dangerous precedents.